We have to get a little geeky today. I want to talk about the role of history and tradition and how they now play out given the Supreme Court's decision in NYSERPA versus Bruen and how to apply it to issues of modern day gun control. Stay tuned. Let's talk about the Second Amendment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks, got to get a little geeky here. Under NYSERPA versus Bruen, there's a way that courts are supposed to apply the Second Amendment for determining whether or not a modern-day gun control regulation or law violates the Second Amendment and should be struck down or is constitutional. We've talked about how certain longstanding regulations involving the misuse of firearms, such as you can't use a gun to commit murder and you can't use a gun to commit a rape or robbery, is the sort of thing that does not violate the Second Amendment, because going all the way back to our founding in 1787 when the Constitution was adopted, in 1791 when the Second Amendment was adopted, those were long-standing understood restrictions on your right to keep and bear arms. Again, you could not misuse guns. So the question is, how do we figure out what kind of restrictions, if any, on our right to keep and bear arms is allowed based on the Supreme Court's precedent of the Heller case in 2008 and the NYSERPA versus Bruen case in 2022? Well, today I want to talk about the role of history and tradition. But specifically, I want to remind you how we get to the issue of history and tradition. Just to jog your memory, the text of the Second Amendment says in operative language, the right of the people to keep and bear arms shall not be infringed. Now, the Supreme Court has defined every single one of those words, which is the people means all Americans, to keep means to possess, to bear means to carry in public, the arms means anything that can be used offensively or defensively, and all bearable arms are presumptively protected under the Second Amendment. And of course, infringe means basically to burden, to restrict, or to harass in some way. Any kind of restriction or limitation is, of course, an infringement. So that is the text. What the Supreme Court said in NYSERPA versus Bruen is you start with the text of the Second Amendment, which, by the way, the Bruen test is really the Heller test, just renamed the Bruen test. The Heller court in 2008, with Justice Scalia writing, did the exact same methodology and approach that the NYSERPA versus Bruen court did. The only difference is that the NYSERPA versus Bruen court was extra clear on how you do some of the details here because they felt the lower courts had screwed up so badly and were confused, either on purpose or otherwise, that NYSERPA versus Bruen broke down the test in more detail than they articulated in Heller, because I think in Heller, when they wrote that decision, they didn't realize the lower courts were going to screw this up and pretend to be dumb and not understand the meaning of the Second Amendment. So NYSERPA versus Bruen tried to put an end to that misbehavior by the inferior courts. Of course, the lower courts are inferior courts because that's what they're referred to under Article 3 of the U.S. Constitution. Now, with that said, NYSERPA versus Bruen says you start with the text of the Second Amendment, which the Supreme Court has clearly defined. And once you define the text of the Second Amendment and any sort of necessary implications, such as the right to train with the gun is necessarily implicated by the Second Amendment, the right to have ammunition is necessarily implicated by the Second Amendment, the right to have magazines in modern semi-automatic firearms is necessarily implicated by the Second Amendment, and so on and so on. So once you deal with the text of the Second Amendment, plus any necessary implications from the text, for example, the right to keep and bear presupposes that we have to be able to acquire firearms, and as a result, of course, it necessarily implicates the right to acquire firearms, which means how do people acquire firearms? The answer is they either purchase them from someone or they go out and make them. Thus, both the right to purchase as well as the right to make are protected by the Second Amendment. That's how it should work, and that's how it basically works in most of the country, with a few outlier states that are going to have to get spanked, and will do so, in my view, very soon. So once we start with the text, if a modern-day gun control law implicates the text of the Second Amendment, what happens next? What does the court do? What the courts are supposed to do is, and this is where I want to get a little geeky, because this is where there's some confusion. It's not hard. You totally can understand this, but there's an attempt to confuse matters on purpose, in my view, by the anti-gunners and the government defendants. So I want to make this crystal clear because the Supreme Court was crystal clear, and anyone that says otherwise is frankly someone who's trying to mess up our Second Amendment rights as best they can, and that's why they're trying to pretend, we don't understand, this is so confusing, this is so hard. BS. It's not hard. You can understand it, they can understand it, and the fact is the anti-gunners understand it. They just don't want to understand it, is my view. Okay, so once the text of the Second Amendment is implicated by a modern-day gun control, what happens next? The answer is the Supreme Court teaches us. The Supreme Court says that we are to use history of American firearms law, starting at the time of the founding, to determine whether or not there is a tradition of regulation. So let me be very clear about this, and then I'm going to give you the language from Bruen to prove my point. After the text of the Second Amendment is implicated, the burden of proof shifts to the government. Think about this in the context of a criminal case. When you walk into court, when you've been accused of a crime, you are presumed innocent under the U.S. Constitution, under the Bill of Rights. And the government bears the burden of proof in a criminal case to prove beyond a reasonable doubt that you have committed a crime. And if the government cannot prove beyond a reasonable doubt that you've committed a crime because you're presumed innocent, the government loses that criminal case. And it doesn't matter why the government loses, by the way. The government may lose the case because they're incompetent. The government may lose the case because they can't find the evidence. The government may lose the case because they're not persuasive in court. The government may lose the case because they can't find the murder weapon. The government may lose the case because a critical witness passes away a week before the trial, and so on, and so on, and so on. But the point is, it does not matter with respect to our right under the Constitution, our presumption of innocence. It doesn't matter why the government cannot prove beyond a reasonable doubt that you've committed a crime. So again, if the government has any kind of confusion, mess up, ambiguity, whatever it is, the government loses. That's just how it was. The presumption is in favor of liberty and innocence. Now, I want you to think of that metaphor as we apply to the Second Amendment. What I mean by this is, once a modern-day gun control law is implicated by the text of the Second Amendment or anything necessarily implicated by the text of the Second Amendment, the burden shifts to the government. And basically, the pro-Second Amendment plaintiffs can literally sit on their hands and wait for the government to act. Now, here's the key point. The government has the burden to show, by looking at history at the time of our founding, that there is a longstanding tradition of regulation. So, again, government bears the burden to demonstrate that there is a tradition of regulation in America for a particular type of firearm that is analogous to what they have enacted today in modern-day America. So the way history and tradition interacts is as follows under Bruen. The government looks to all of history. That is what they look to. They look to history. They're looking to history, okay? But when they look at history and all of history, okay, what are they looking for? They're not looking to see how many wives Henry VIII had. They're not looking to see the year that a fire burned down the city of London. So what exactly is the government looking for and must find to justify their modern-day gun control law when the burden shifts to them because the text of the Second Amendment is implicated and now the burden shifts to the government? They look to history. Their job is to identify and flag a long-standing, well-established tradition of firearms regulation of a particular type in modern day in America. So that is the interrelationship between history, which is what government searches for, and what they're looking for specifically is a tradition of firearms regulation that is sufficiently analogous to a modern-day gun control law so that modern-day gun control law can be viewed as consistent with the text of the Second Amendment. The best example I think of this and the easiest to understand is if you pass a law today that says you cannot commit murder with a firearm, you pass a law today that says you cannot use a firearm to commit a rape or a robbery. That is a 21st century, gun-related law, obviously. So the text of the Second Amendment is technically implicated because it deals with, firearms. But then when government goes back and looks at the history of the United States, can they find a tradition of regulation or a tradition of actual laws? By the way, regulation means actual laws that are enforced. Not some theory, not some concept, not some abstract debate by some academics, but actual laws at the time of our founding, regulations that were enforceable with the force of law. Can the anti-gunners or the government demonstrate there's a tradition of regulation using actual laws? When it comes to our use or misuse of firearms to commit murder, rape, and robbery, the answer is obviously they can find that because if you go back to our founding, people were not allowed to misuse firearms or any arms for that matter to commit those malum in se crimes of robbery, murder, and rape. So that would be an example of, even though we all have Second Amendment rights to keep and bear arms, that does not extend to allowing you to misuse firearms to commit those crimes. And the way we figure that out is that the government would be able to, and there's no debate about this, go back to the time of the founding to say, look at these laws that prevented you from using a firearm for these particular purposes. So now that we have a 21st century law that says you can't use a gun to commit these malum and say rape, robbery, and murder crimes, there's a long-standing tradition of that in the United States. Therefore, those modern-day laws that prevent that do not violate the Second Amendment. You see how that works? It's very straightforward. It's not hard. Now, let me make something clear. This is extremely important. The government bears the burden to show actual laws at the time of the founding, historical analogs they're called, that are sufficiently similar or identical to modern-day gun control laws. Otherwise, if the government cannot do this, they lose the case. Now, I want to do two things here. I'm going to show you the language from Bruen that teaches you that I am correct, that is actually they have to come forth with historical analog laws to win. And then I'm going to talk to you about what happens if they fail to do so and how they're trying to get around this, but I'm not going to let them do it, because I'm going to teach you how to stop it and nip it in the bud before the anti-gunners can even get a toehold on their silly arguments, which I'm going to flag and then beat up. Okay, so this is what the holding in Nyserpa versus Bruen says. You have to find a regulation at the time of the founding. Here is Bruen's language, quote, in keeping with Heller, we hold, the center part of the case. In keeping with Heller, we hold that when a Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, which means law, the government may not simply posit that the regulation promotes an important interest, no balancing test, we talked about that, no balancing test. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, ding, 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 important. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation, period, close quote. There's a lot in this holding. Now, this is the holding of Bruen. This is not dicta. As you know, the holding is the essential decision made by the Supreme Court. Everything else in that 100-plus page opinion is what's known as dicta. It can be very important, very persuasive, extremely helpful. But the holding, the actual decision in the case of Bruen, has some critical language that you must understand, and do not misunderstand, and don't let the anti-gunners dupe you or dupe judges that you're appearing in front of about some of these issues. In the holding, let's look at what it says. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively, hear what I just said? Presumptively protects that conduct. Presumptively. Have you heard the word presumption or presumptively before? Yes, you have. The presumption of innocence in the context of a criminal trial, which you're guaranteed under the Bill of Rights. Presumptively. Why is this important? As I mentioned earlier, you have, if a gun control law in modern day America is implicated by the text of the Second Amendment, it is presumptively unconstitutional. I repeat, if a gun control law in modern day America implicates or is touched by or somehow falls within the text or the necessary implications of the text of the Second Amendment, it is presumptively unconstitutional. No different than when you walk into a criminal case, you are presumed innocent. And the government is presumed to lose that case. And the government can only win that criminal case if it comes forth with powerful evidence to prove beyond a reasonable doubt that you committed the crime. Likewise here, because this is Bruen, not me, the Constitution presumptively protects that conduct, meaning the right to keep and bear arms. The government bears the burden to overcome that presumption. And remember, if the government cannot overcome that Second Amendment presumption, it loses. And it doesn't matter why it can't do it. And this is what's so important, because the anti-gunners and the government right now are playing dumb on purpose because they know they're in big-time trouble when it comes to the Second Amendment. They're saying things like, we don't understand the Second Amendment. We need historians to teach us how to do our job in interpreting the Second Amendment. We don't understand history. We're not historians. We don't understand. What time period do we look to? Stupid. Plain stupid, and on purpose. Either people are not trying, or They know what they're doing, and they're pretending to be dumb. Like a kid that can't do his homework because he says, I can't do my homework because I don't understand it. Some federal judges and some people in the United States are trying to get around the Second Amendment by feigning ignorance, in my view. But the Constitution presumptively protects that conduct, and if the government is dumb, and if the government can't figure out historical analog, and if they can't make an argument, and there's any doubt whatsoever, guess what? The government loses. The gun control law must be struck down because the presumption is in favor of the conduct. Just like the government fails to prove its case beyond a reasonable doubt in a criminal case, if the government fails to prove its case, meaning that there's historical analogs going back to the time of our founding, justifying the modern-day gun control regulation as part of our tradition, our historical tradition of regulating firearms, which is very few, far between of those, the government loses. Period, full stop. No excuses. Government can come forth. We're not smart. We can't argue. We can't find a historian. We can't find the history. We need more time. Doesn't matter. Government loses just like they would lose a criminal case. Never lose sight of that. Extremely important. Now, the Supreme Court, and this is key because I want to talk about the history and tradition because sometimes it's confused. In the holding, the court goes on, as I read this before, quote, the government must demonstrate that the regulation, which is the modern day regulation, is consistent with this nation's historical tradition of firearms regulation. You see what I just read? Bruen says that the government has to show that the modern day gun control law is consistent with the nation's historical tradition of firearm regulation. Now, there's a lot packed into that. Again, the government has to look to history, but when they look to that history, they have to find something. They can't just look at history. They have to find a specific thing. And what do they have to find? They have to find, according to Bruen, quote, a tradition of firearm regulation to show it's a tradition of firearms regulation consistent with the modern day gun control law they're trying to uphold. That is the holding of Bruen. And that is how history and tradition interact under Bruen. The government looks to history, and when it looks to history, it's trying to find a particular thing, which is a longstanding tradition of firearms regulation. The word regulation is critical because, again, it's not some theory. It's specifically finding actual enacted laws. Now, this is extremely important because the anti-gunners are trying to advance a new argument, and that new argument is essentially saying that just because Americans did not act in 1791 to pass a particular kind of gun control law doesn't mean they lacked the authority to do it. All we care about in the anti-gun government community that hates guns is we want to be able to show that at the time of the founding, the legislators, the Americans, the people had the authority or the power to enact gun control legislation of the type we've enacted today. No. Totally wrong. Do not listen to Mark Smith and the Four Boxes Diner. You listen to Nysurper versus Bruen, the Supreme Court, because they're not talking about you had the authority and decided not to act. No, they say the government must demonstrate that the regulation, modern day regulation, is consistent with the nation's historical tradition of firearm regulation. If they didn't pass the law, there's no regulation. If there's no regulation, the government loses the case. So, again, don't let anti-gunners in the government dupe us into anything else. This is no different than a criminal case. If the government can't come forth with powerful persuasive evidence showing a historical tradition of a particular firearms regulation consistent with the modern day law, they lose. No excuses, no how. It's Bill Belichick and the New England Patriots telling people it doesn't matter why we lost. We lost. That's all that matters is the score on the board. And when it comes to the government and our Second Amendment rights, because the right to keep and bear arms is a fundamental right at the highest levels of society in terms of importance, if there's any ambiguity, if there's any doubt, any confusion at all about whether or not the government has successfully come forth with historical analogs, we know what to do, which is the government loses. And that's not just what I said. That is what the U.S. Supreme Court said in footnote number 11 of Nysurper versus Bruen, when they say that when they have any doubt about, in that case, in that context, the Sir John Knight's case, when they have any doubt about the meaning of that historical analog of the Sir John Knight's case, they defer to what? The command of the Second Amendment's right to keep and bear arms. They call it the Second Amendment's command. Not my language, the Supreme Court's. The Second Amendment is a command to government. The government must follow, and it's a very high burden for this government to justify modern-day gun control regulations under the Second Amendment's text and the history and the tradition of firearms to the extent they existed at the time of our founding. High burden, and if the government doesn't like it, it's too bad. We're dealing with a fundamental right, and when in doubt, freedom wins. The right to keep and bear arms wins. Okay, folks, I know this is a little geeky. I apologize for that, but I hope you learned something here today, and if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.